Welcome to Spring Law's Spring Forward Legal Updates webinar series. This series is designed to provide a comprehensive legal overview of key issues related to employment law and human rights in Ontario. Spring Law is a virtual employment law firm advising on workplace legal issues for employers, employees, freelancers, and executives from a wide range of industries. We hope you enjoyed today's webinar and find it useful and informative. To reach our team, please visit us at springlaw.ca. And now to our presenters.
Good morning, everyone, and thanks for taking the time to join us today. My name is Shauna Fabrizi, and I'll be presenting alongside my colleague, Jeffrey Adams. We're both employment lawyers at Spring Law, and today we'll be walking through some of the legal and practical issues employers face when managing medical leaves, disability benefits, and return to work situations. Jeff and I both work closely with employers on workplace issues, including accommodation, leave management, workplace policies, and employment disputes. And a lot of what we'll discuss today comes directly from the types of situations we see employers navigating in practice. If this is your first Spring Law webinar, welcome. We're a virtual Canadian law firm focused on employment law, contracts, and litigation. And we regularly host these sessions to share insights with employers. And as we go through this presentation, feel free to drop any questions into the chat. We'll keep an eye on them and try to address as many as we can towards the end of the session. You can also download today's slides in the Handouts tab if you'd like to follow along or save them for later. And if you're looking for more resources after the session, you can visit springlaw.ca, where you'll find our weekly blog on employment law developments, information on subscribing to our monthly newsletter, and details about our subscription program and other employer resources. And so we can go to the next slide, specifically the land acknowledgement. So before we begin, we would like to acknowledge the land we live and work on is the traditional territory of the Anishinaabe, Haudenosaunee, and Wendat peoples, and part of the treaty lands of the Mississaugas of the Credit First Nation. And we recognize their long-standing stewardship of this land, and we're grateful to live and work here today. So on to the next slide, legal disclaimers, a quick lawyer note. Today we're sharing general legal information and not legal advice. And so we'll leave this disclaimer up for a moment so that everyone has a chance to take a quick look. And next I'll turn it over to Jeff to provide a presentation roadmap.
Thanks, Shauna. And just to, as people are formulating questions as we go through this presentation, I just want to let people know that I have a spinal cord injury and use a wheelchair, which I mentioned in the context that it gives me an ability to understand from an experienced life experience point of view some of the nuances of disability management and accommodations. So I just wanted to, as you mentioned, that in terms of the formation of the questions. So today we're going to go through, an introduction, the legal framework. We're going to talk about human rights. We're going to talk about the duty to accommodate, which breaks down into a number of components, and importantly, the limits to the duty to accommodate. A lot of our employers assume that, correctly, that it's a very, very high bar, but it's not so high that it is out of reach. So we'll talk about the limits of the duty to accommodate, WSIB and benefits, which is a complex area of law, and short-term disability and long-term disability benefits. Next slide. Advance one more, please. There we go. So managing and navigating illness and disability in the workplace involves managing obligations alongside business needs, and it's important that we recognize both of those. And employers have to navigate common law principles, human rights legislation, statutory regulation, obligations, and specific workplace agreements. Failure to address these areas adequately can expose employers to both legal and financial risks. And so this presentation in large part is to provide a roadmap to manage those issues and mitigate risk as well as possible. We're going to focus on the provincial jurisdiction of Ontario, but all of the lawyers at Spring Law practice in the federal jurisdiction, as well as a number of other provinces. So we can cover all the jurisdictions in Canada, including federal. Next slide, please. And turn it over to Shauna again for the framework.
Thanks, Jeff. So we'll start with the legal framework employers should keep in mind when dealing with illness and disability in the workplace. And we can move to the next slide. And so when we're talking about managing illness or disability in the workplace, one of the realities employers face is that there isn't just one law that applies. Instead, several legal frameworks come into play at the same time, and they often overlap. The first and usually the most significant is the Human Rights Code. The code prohibits discrimination based on disability and creates the duty to accommodate employees with disabilities up to the point of undue hardship. We'll walk through that concept in more detail later in the presentation. We also have the Employment Standards Act, which sets out the minimum statutory rights for employees in Ontario. That includes job protected leaves, protections related to illness or injury, and requirements around benefit continuation during certain leaves. Another important piece is common law, which develops through court decisions. Common law establishes broader principles that govern the employment relationship, including things like reasonable notice on termination and the duty of good faith between employers and employees. If you're interested in that topic, we've included a few case law resource slides at the end of the presentation materials. And then there's WSIB, which applies where an illness or injury is work-related. The WSIB system has its own return to work obligations and cooperation requirements. And finally, many workplaces also have disability benefit plans, such as short-term or long-term disability coverage, which can create additional contractual obligations depending on the terms of the policy. And the key point is that these frameworks don't operate separately. They overlap, and that's why managing illness and disability in the workplace can become complex fairly quickly, and that's where legal guidance becomes helpful. A big part of our work is helping employers review their policies and practices to make sure they align with these obligations and reduce legal risk before issues arise. Now let's turn to the common law framework and what it means for employers when disability becomes part of the picture in the workplace. Under common law, employers in Ontario generally have the right to terminate employment without cause, but that right does come with important limits. First, the termination cannot be discriminatory, including discrimination based on disability. Employers must also provide reasonable notice of termination or pay in lieu unless there is a valid and enforceable termination clause in the employment contract or in rare cases where the contract has been frustrated. When disability is involved, the analysis can become more complicated. Courts sometimes extend reasonable notice periods for employees with disabilities, recognizing that their ability to secure comparable employment may be more limited. Another concept that occasionally arises is frustration of contract. This can apply where a disability permanently prevents an employee from performing the essential duties of their role. But it's important to keep in mind that frustration sets a very high legal threshold, and employers need clear medical evidence before relying on it. And finally, employers must ensure that they have met their duty to accommodate before moving toward any termination. For that reason, again, we always encourage employers to take a careful, well-documented approach before making any termination decision in those circumstances. Next, I'll turn it to Jeff to talk about human rights.
Thanks, Sean. And just to reiterate, these are very complex areas where different laws and regulations and insurance policies overlap. Often these circumstances are very nuanced as well. It's a difficult area to conduct business in, Before law, I ran a couple businesses, and I can tell you from experience that this is a very complex and difficult area of law. So if you feel like making accommodations and making accessibility real is difficult, I can validate that, and it's where we hope we can provide some support and help. Next slide. Sorry, yes, down the slide, please. So the first step when you're doing a human rights evaluation is to define disability and sort of understand what disability is. And it includes physical, mental, and episodic conditions. Physical accommodations are often relatively the easier ones to make. You know, when I show up to a meeting, it's obvious that I'm in a wheelchair. The mental health issues are not, they're invisible disabilities and can be more difficult to conceive of and understand. But the Human Rights Code defines disability very broadly, covers a wide range of conditions, including, as I mentioned, episodic and invisible impairments. The policy behind this is to ensure inclusivity and equal treatment in the workplace. And again, if you're uncertain whether your policies align with this definition, we can provide a detailed legal review of that. Next slide, please. So when an employee approaches and asks for accommodations, they do need to provide medical information showing how their condition affects their work. Employers can only, not only should only, but can only request details relevant to the accommodation process. So this means you cannot ask what the diagnosis itself is, but you can ask what the functional limitations are that the employee has while at work. Again, we do this all the time. We can assist you in creating some standardized forms or processes for these requests to ensure consistency, compliance, and to make sure that you're operating within the law. Next slide, please. So the duty to inquire is part of the accommodation regime, meaning the framework and structure of it. And the duty to inquire arises when employers notice signs of potential disability. And this can be very nuanced things like frequent absences, declining performance. And a lot of employers tend to assume that things like this are worthy of discipline, and they sometimes are. But if you have an employee who has had a good attendance record for years and suddenly misses 4 days in a row, the first reaction we encourage is to ask why. Their duty to inquire means you have a conversation with the employee and say, look, you've been late 3 days in a row. Is there something going on? Is there something that I need to know about that I can help with, that I can provide accommodations for? And that's the duty to inquire is a big part of the procedural component of the human rights regime. But these proactive conversations can prevent legal claims and foster trust with your workforce. So they're valuable to do. They're not only things you must do, but they're very, very valuable to do too. Next slide, please. And I'm going to turn back over to Shauna for these next slides.
Thanks, Jeff. So we'll now turn to some Supreme Court guidance on the duty to accommodate. So one case that's particularly important when we talk about the duty to accommodate is the Supreme Court of Canada decision in Moore and British Columbia. Although the case arose under British Columbia's human rights legislation, the Supreme Court decisions do apply across the country. And so that means that the principles from Moore are highly relevant when we interpret the Ontario Human Rights Code and an employer's accommodation obligations here in Ontario. In that case, the court reinforced that the duty to accommodate requires employers to take all reasonable and practical steps to prevent discrimination against employees with disabilities. The court also highlighted a few key principles. First, accommodation is about equitable access, not special treatment. The goal is to remove barriers so employees with disabilities can fully participate in the workplace. Second, the burden on employers is significant. So if an employer claims that accommodation is no longer possible, they must be able to demonstrate, or was never possible, they must be able to demonstrate that all reasonable and practical options have been explored first. And that ties into the concept of undue hardship. While accommodation does have limits, employers need clear, objective evidence, such as financial or operational impacts, to show that further accommodation is not feasible. Another point the courts often recognize is that the size and resources of the employer matter. Generally speaking, larger organizations are expected to have greater capacity to accommodate. So the key takeaway from Moore is that the duty to accommodate is a proactive and meaningful obligation. Employers need to consider how workplace policies and decisions may affect employees with disabilities and then take reasonable steps to remove barriers when they can. Next slide, please. Now let's turn to the two responsibilities employers have under the Human Rights Code in Ontario. That is the procedural duty and the substantive duty. These two duties work together, and it's important to understand that falling short on either one can lead to a breach of the code. The first is the procedural duty, which focuses on the process. Employers are expected to actively work to understand what the employee needs in terms of accommodation. That usually involves gathering the right information, speaking with the employee about their limitations, and considering possible accommodation options. The process doesn't have to be perfect, but employers do need to show that they engaged seriously and in good faith with the request. The second piece is the substantive duty, which focuses on the outcome. Once reasonable options have been identified, employers are then expected to implement accommodations that allow the employee to continue working, unless doing so would create undue hardship. That might involve modified duties, adjusted schedules, changes to workload, or other practical workplace adjustments. The key point here is that both the process and the outcome matter. It's not just enough to say that accommodation was considered. Employers need to show they engaged in the process and implemented reasonable solutions where possible. We can move to the next slide. A key part of the procedural duty is the collaborative process. Accommodation is a shared responsibility. So both the employer and the employee have a role to play. From the employer side, the expectation is that you actively engage in the process, working to understand the employee's needs and considering possible accommodation options. From the employee side, they're expected to participate as well. That means providing relevant information, communicating about their limitations, and cooperating with reasonable accommodation options, even if the solution isn't their preferred one. One point that often surprises employers is that accommodation doesn't have to be perfect. The law doesn't require the ideal solution, it requires a reasonable solution that addresses the employee's functional limitations. Another important point relates to medical information. Employers are generally entitled to understand an employee's functional limitations, but not the diagnosis itself, except in limited circumstances. Courts and tribunals look closely at whether both sides participated in the process. If either side refuses to engage, that can amount to a breach of the procedural duty to accommodate. Key takeaway here is that communication and documentation matter, And a clear, well-documented process helps demonstrate that the employer approached accommodation seriously and in good faith. And so we can move to the next slide, and I'll turn it over to Jeff.
Thanks, Shauna. We can jump to the next one to discuss this. So the duty to accommodate does have limits. And to frame this, the purpose of accommodations is to allow the employee to get back to work, and to work effectively. So that's the framework that we're working under. And again, to reiterate what Shauna said, there are two parts to the duty to accommodate. It's what you do and how you do it. So the substantive part and the procedural part, what you do and how you do it. And while employees have a right to accommodation, they can't demand a specific solution if another reasonable option effectively meets their needs. And this is a very important point. Under the Human Rights Code, the Ontario Human Rights Code, employers must provide accommodation that enables the employee to perform their job without undue hardship. But they are not required to implement preferred or ideal accommodations. And that's where the collaborative process comes in. This should be a conversation between the employer and the employee to arrive at a mutually agreeable solution. Employers are allowed to and should propose alternative solutions, provided that they effectively address the barrier at issue. One example is offering flex hours instead of remote work that might meet the needs of an employee with a disability. There are other ways to creatively come up together with solutions that work. But again, communication is absolutely critical. Employers should explain why a simpler or different accommodation is sufficient, and engage in dialogue again. And again, it's a must do, but it's also a good thing to do because it builds trust with your employees. Document, 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 right? It's keeping records of all the discussions and options considered, is a must. It demonstrates good faith, it protects against claims of insufficient accommodation, and it makes Shauna and my jobs a lot easier. So this is a little bit self-serving, but documentation is critical. Once you get, if you're in business long enough, you will likely face a human rights allegation, and to be able to resist it, documentation is a must. Next slide, please. So I want to talk a little bit about the substantive limits, because as we mentioned at the front end of this presentation, the duty to accommodate is not unlimited, right? It has clear limits. Employers are required to make meaningful efforts, but only up to the point of undue hardship. Undue hardship is a very high bar, but it's not out of reach in some circumstances. So there are really three areas where undue hardship can be met. Financial costs, but I want to be clear, the financial costs must be so significant that they jeopardize the business's ability to operate. And again, like Sean mentioned, different sized organizations or the different sizes of organizations matters. And courts consider available subsidies, other supports, and the size of the business before accepting cost as a defense. A big one is health and safety. So I've got a number of clients who operate factories or warehouses or manufacturing plants. And in those circumstances, safety is a major issue. So risks can arise based on accommodations. But the risk posed by the accommodation must be substantial and evidence-based. For example, accommodating a disability that creates significant safety hazards may meet the undue hardship threshold. But again, this is going to rely on previous decisions, case law that's on the books, and how courts interpret the undue hardship standard. External funding is an interesting one because there are government grants that will help mitigate accommodation expenses, and employers are expected to explore all funding opportunities to ensure that the cost issue is not or can be mitigated as much as possible. So again, by documenting all the accommodation efforts, obtaining expert guidance where necessary, employers can demonstrate compliance and effectively defend against claims. And this approach ensures a fair balance between employee rights and operational feasibility requirements. Next slide, please. So this area, the mental health and accommodation, is a very, very complex and difficult area of law. It's a critical part of the accommodation regime under the Human Rights Code, and employers have to offer accommodations to account for mental health issues that arise in the workforce. Promoting workplace awareness and reducing stigma to mental health issues is an important and proactive step. Legal risks arise if terminations relating to mental health fail to meet accommodation requests. So this again, it relies heavily on documentation. No termination can be linked in any way to a disability. That's just, it's fundamental. And it doesn't have to be the only reason for the termination. If it forms any part of the reason, the legal jeopardy is real and high. Next slide, please. So the duty to accommodate, just we'll summarize it. We got a procedural duty where employers must engage in good faith discussions, investigate employee needs, document all efforts to demonstrate compliance. There is a substantive duty. Accommodation has to address the employee's limitations and enable them to perform their job unless it causes undue hardship. Simplified accommodations are acceptable if they meet the employee's needs, and there are limits to accommodation. The code restricts undue hardship analysis to cost, health and safety risks, and external funding. And employers are not obligated to provide the employee's preferred accommodation if other reasonable options exist. So just to explain the safety issue again, you've got competing legal obligations under the Human Rights Code and the Occupational Health and Safety Act. Section 25 of the Occupational Health and Safety Act requires you to do everything reasonable in the circumstances to protect the safety of the workers. And that often comes into tension with the obligations under the Human Rights Code. I see a lot of questions coming in. We're gonna answer them at the end of the presentation, but I see some good ones coming in. So we had some meaty bones at the end. I'm gonna turn it back over to Shauna for the WSIB portion.
Thanks, Jeff. So we've talked about accommodation and the responsibilities employers have under the code. In practice, these situations rarely involve just one legal framework. Employers are often dealing with WSIB claims or disability benefits as well, which come with their own obligations. So let's now turn to WSIB and benefits and look at how those frameworks interact with accommodation. WSIB comes into play when an employee's illness or injury is work-related. When a claim is active, employers have a legal obligation to cooperate with WSIB in the return to work process. In practice, that means working with the employee and sometimes with WSIB to identify suitable work or modified duties that match the employee's abilities while they recover. One thing employers should pay close attention to here is documentation. It's important to keep clear records of the steps you're taking, so conversations with the employee, medical updates, and the accommodation options you've explored. That record can become very important if the situation is later reviewed. Another area where employers need to proceed carefully is termination, as Jeff has already touched on. If an employee is receiving WSIB benefits or recovering from a workplace injury, any termination decision will be closely scrutinized. Employers need to be able to show that the decision is completely unrelated to the injury and that genuine efforts were made to support the employee's return to work. The goal of the WSIB framework is to support employees in returning to work safely when they are able, while ensuring employers meet their legal obligations in the process. Because these situations can be legally sensitive, it's often worth pausing and getting legal advice before making any significant decisions, including termination. Next slide, please. Another area employers need to manage carefully is disability benefits, because mistakes here can also create significant legal exposure, and particularly if the employment relationship later ends. One issue is benefit coverage during leaves. For statutory leaves, the general rule is that benefit coverage must continue as long as the employee continues to pay their portion of the premiums. In contrast with non-statutory leaves, the situation can be different. If benefit coverage will end during an extended leave, it's important to communicate that clearly to the employee in advance. In many cases, employers will offer employees the option to continue their benefits at their own expense, which can help avoid gaps in coverage. It's also important to review your group insurance policy carefully, because many plans require employees to maintain certain active employment status in order to remain eligible for benefits. For that reason, employers should be cautious about changing an employee's status to inactive, as that can unintentionally affect their coverage. Clear communication and a careful review of your benefits policies are essential when an employee is on disability leave, and handling this properly helps avoid disputes and ensures that employees understand what coverage is available to them. And I'll turn it over to Jeff now to talk about short-term and long-term disability.
Thanks, Shauna. So we can advance a couple slides. Yeah, thank you. And one more, please. Thank you. So this slide is fairly self-explanatory. There are two types generally of disability leave: short-term disability, long-term disability. Short-term typically covers illnesses or injury of a short duration, usually 13 to 26 weeks. And some employers choose to self-insure for your short-term disability because it can be quite expensive through a policy provider. Long-term disability covers extended absences, usually beyond the 26-week mark, and there are some benchmark timelines in the LTD process where an employee can be eligible for LTD in the first 2 years, and then that status can change at the end of the 2 years because of the definitions in the policy. So it's important to know your policy carefully and be able to explain that to your employees and to your leadership as best you can. So the legal protections, the duty to accommodate disability to the point of undue hardship, it's embedded in the human rights regime and legislation. Employment standards legislation that contains protected leaves that may apply in advance of STD and LTD, but they also can protect reemployment rights during disability leave, where you have to protect the position that the employee is returning to and return them to that position or a substantively similar one. The common law is overarches all of this, and the entitlements at common law form a part of the employee's compensation package. So when we talk about compensation, we talk about salary, base salary, bonuses, benefits, but the compensation as a whole incorporates anything the employee gets that is of value. Next slide, please. So just to be clear, employees on STD or LTD are still considered employees unless and until they're terminated. But termination during leave or shortly thereafter is generally speaking a major legal risk. And part of the risk is whether or not the termination is in fact linked to a disability. If there's even a sniff of it, the employee will go get counsel and you'll see a demand letter. And a demand letter or a statement of claim, whether or not it's valid, has to be defended. So the legal jeopardy is multi-layered here. And again, you can be 100% right. It can be totally unconnected to disability. If you face an allegation, it has to be defended. So that's um, something that makes it difficult. It does make it difficult to conduct business in Ontario. There are a couple of main ways to deal with employees who have been on long-term disability for an extended period of time. And by extended period of time, we're talking years, not months. Um, and those two ways are either through asserting job abandonment, which is very difficult to do, or a frustration of contract. And we get the frustration of contract is made simpler when there is a determination of total disability and the employee goes on LTD for longer than 2 years. There's still a requirement to ensure that the employee will not be returning. And again, it's a process that must be undertaken by the employer that we can assist with if and when the time comes. So we don't really have time to get into the nitty gritty of abandonment or frustration of contract. But if you do have an employee who has been on LTD for an extended period of time, reach out. We can discuss the nuances of the specific circumstances. Next slide, please. And I'm going to turn it back over to Shauna to deal with this section.
Okay, thank you, Jeff. So we'll talk about the key considerations now. And so a question we hear from employers quite often is, can you terminate an employee while they're on disability leave? And the short answer is yes, in some circumstances, but it needs to be approached carefully. First, the termination cannot be related to the employee's disability. If an employer is terminating someone who happens to be on disability leave, they need to be able to show that the decision is based on a legitimate, non-discriminatory reason, such as restructuring or operational changes. Another situation that sometimes arises is frustration of contract. This can apply where a disability prevents the employee from returning to work indefinitely with no reasonable prospect of recovery. But this is a high legal threshold, and employers generally need clear medical evidence before relying on frustration. Even where termination is lawful, employers must still meet their minimum statutory obligations, and in some cases, common law notice or damages may also apply. Another important piece to consider is benefits continuation. So reviewing the terms of the policy or the benefits plan, since those terms often govern what happens to coverage when employment ends. And in many situations, benefits must continue during the contractual notice period and always during the statutory notice period. If coverage ends too early, employers may face additional liability, particularly if the employee loses access to disability benefits they otherwise would have had but for the termination. So terminating employment while someone is on disability leave carries significant legal risk. It's something employers should approach carefully and with proper legal guidance before moving forward. And we can move to the next slide. To wrap up this section, here are a few practical best practices for employers when dealing with disability leaves and return to work situations. First, obtaining appropriate medical documentation. Employers are entitled to understand an employee's functional limitations and their potential ability to return to work so they can properly assess accommodation options and plan next steps. Second, before moving toward termination, employers should pause and consider their accommodation obligations. That means looking at whether there are reasonable adjustments or modified duties that could allow the employee to continue working in some capacity. And finally, this likely won't surprise you coming from us, but it's often wise to speak with an employment lawyer before making major decisions in these situations. Disability related terminations can be legally complex, and getting advice early can help employers navigate the process carefully and reduce the risk of costly disputes later on. And so I'll turn it over to Jeff.
Thanks, Sean. So we're going to talk about pre-employment considerations and steps. Next few minutes, thank you. So the best practices for employers are to avoid pre-employment issues is to standardize interview questions. So ensuring and doing so to ensure that they're relevant, consistent, and focused on job qualifications, right? You got to avoid discriminatory questions like, do you have a disability? I mean, the problem with these questions is that we all know we don't ask that, but some of the things that happen innocently can, you know, unfortunately step into some discriminatory areas. Asking someone, you know, what they did with their kids on the weekend, assuming they have kids, stuff like that, rather than, you know, straight up, do you have children? And there are I've had cases where the employee during an interview had children in the background and then later alleged that resulted in them not getting a position. So this is a quagmire in many ways. But standardizing the interview questions, developing clear, detailed job descriptions that outline essential duties and required skills, training your hiring managers on permissible and impermissible inquiries, having a witness in some of the interviews or recording the interviews is a good protective step. Using a structured scoring system to evaluate candidates objectively and reduce the risk of unconscious bias. And we're moving into areas now where a lot more AI is being used, and there has to be a very careful consideration made when using AI to filter job applications, because there have been cases where the AI itself, because of the way it was prompted or instructed, arrives at biased decisions. But again, documenting the entire hiring process to demonstrate fairness and compliance is critical. Next up, please. Or next slide, please. So some steps for employers. Generally speaking, employers should take a holistic approach to managing illness and disability. This includes evaluating every case individually, because one of the difficulties with managing disability issues is that almost every disability is somewhat unique. So again, it adds to the complexity, and no sugarcoating here. Managing disability issues is a very difficult process, especially for people who may have never experienced a disability. And that's hopefully where we can help. But evaluating each case individually, seeking timely guidance to ensure compliance. And some practical strategies: early intervention by addressing performance issues proactively and with curiosity, and to discharge the duty to inquire. Maintaining documentation, so tracking accommodation efforts and discussions, even discussions between management where you're flagging potential problems, documenting all of that is important. One of the ways to protect that documentation is to include legal counsel in the communications, whether or not they're actively participating. It's a way to protect the discussions with privilege. Again, as Shauna mentioned, this is self-serving, but call us, right? We've seen many complex cases, and things that may be novel to you may be things that we've seen before, and just the potential for some experiential knowledge is invaluable. Employee training is critical. Ensuring managers understand human rights obligations can save you a lot of angst in the future. So again, employers have to align policies with human rights obligations to foster equitable workplaces, which also minimizes legal risk, right? So you should do this because it's the law and it's a good practice, but doing it will mitigate your legal risks significantly. Having policies is an important thing. There are a number of required policies in Ontario, an accommodation policy under the ODA for certain size businesses, return to work policies, anti-discrimination, harassment, some electronic monitoring policies for certain size businesses. And again, we can provide, if you have questions about what policies you should have and what policies you must have, let us know. We've got a quick list to provide to you for that. Some of the policies I encourage are not mandatory, but act as a bit of an insurance policy, for lack of a better term. So an example would be having a human rights policy. It's not mandatory in Ontario, but it's a very helpful policy to have, because if you have an employee who violates the human rights policy, you have something to point to for discipline purposes. And if you face an allegation of a human rights breach, when you receive the application from the complainant, the reply the reply is on a form, and the form has literally a box to tick. Do you or do you not have a human rights policy? And saying no isn't fatal to the defense, but it's not a good look, right? Because the tribunal reviews the form on the front end, and not having a human rights policy really restricts the ability to make the argument that you're a non-discriminatory employer. So it's a good to have, but a very good to have. So I think we're at the end of our formal presentation. I've seen we've got a bunch of questions coming in. I'm just going to scroll through them. One of the questions that has come in a couple times is the issue of work from home and a return to the office policy. So we went through the pandemic a number of years ago. Everybody went home and worked from home. And so it was a radical shift in the way that work was done. And I got to tell you that people with disabilities were very well, they were very happy with this, because for a lot of people with disabilities, myself included, working from home is just a much better, more efficient way to do things. With using myself as an example, in January and February, there are weeks on end where using a wheelchair means that I really can't leave my house with any degree of ease. So unless I'm going from a garage to a garage, it becomes very difficult. I'm very efficient at home. Some employees are, some employees aren't. And that's, I think, my advice to employers when they're initiating a return to the office policy, is to ask whether you really need it, and whether the employees are working sufficiently at home. If they're getting the job done, why are we asking them to return to the office in the first place? There are some very, very good reasons. Collegiality, collaboration, the culture, but that has to be held up against the reality that some of your employees may just be better off working from home. If it's possible, I always encourage employers to do that, to allow them to work from home. If it's not, we look at ways to provide accommodations if necessary and make the return to the office as lawful as we possibly can. But it's a big issue that it's not it's topical right now, because for the last couple of years we've seen more and more return to office policies coming in. I'm just looking at the questions here.
I can jump in on one, Jeff. So
sure.
Yeah, so we received a question asking, what do you do when an employee suddenly provides a doctor's note saying they're off for a month and you had no prior knowledge? So recognize this does feel disruptive operationally. It's something that's come out of the blue, but legally it is actually pretty straightforward. The note is enough to trigger your obligations. And so you acknowledge the leave. You don't challenge it unless there's a real issue. And so ensuring that the note is sufficient, it does indicate that there are functional limitations and they're unable to attend work, is ultimately enough. So the surprise does not prohibit the employer's legal obligation to accommodate. Jeff, did you have anything to add on that one?
No, that's a good summary. We had another question that says, how do we assess the needs or investigate the needs? How do we know it's disability? And it's a good question, because again, if I show up at your workplace and I'm sitting in a wheelchair, it's patently obvious. But I've got, I might have other disabilities that are not as obvious as the use of a wheelchair. So it's again a nuanced issue. As a person with a disability, my response, and as a lawyer, my response is you ask respectfully and carefully. You don't ask for a diagnosis, but you are allowed to ask. The duty of to inquire allows that. So it's baked into the human rights regime. Again, you have to approach carefully. You have to do it, with respect. But you can ask someone, what accommodations do you need? What can I do to help you do the work that you need to do? And that's what it boils down to. How do you know if it's a disability? By medical documentation. So again, employers are allowed to ask for medical documentation. And if you get what we see quite often, a generic doctor's note, this employee has medical issues and can't return to work for a month. It puts you in a difficult position, because you really do have a right to know when the employee might return to work, what accommodations will be required if and when the employee returns to work. And so you can ask for additional medical information. We often, not right off the bat, but in certain circumstances, we'll ask for a functional abilities form to be filled out, functional abilities assessment to be done, and that will return. It'll go to the healthcare provider, and provide you with some of the information that you need to start preparing for the employee's return. But you have an absolute right to prepare, to organize your workplace, and to know with some certainty, or with as much certainty as you can, what the prognosis and return to work might be. I've got a lot of files lately where the employee has gone on a medical leave of some sort and then wants to return to work. And we generally will ask for a clearance to, especially if it's a lengthy leave or one that has been badly explained. We'll ask for a return to work um, justification or a return to work form to be filled out by the same healthcare practitioner that provided the documentation for the employee to go on leave. We'll ask for them to confirm that they are fit to return to work. And that's critical in a lot of, especially a safety sensitive position. Um, I'm dealing with a file right now where a therapist returned an employee to the workplace after I think it was a 19-week leave. It's quite a lengthy leave. They came back, and their first day back, they were exhibiting um, behavior that triggered some safety issues, standing on the forks of a forklift, stuff like that. So, again, we rely on the medical documentation and the medical experts, but you can challenge that. You can ask for more and better. You can ask for a reevaluation in extreme circumstances. You can ask for an independent medical report to be generated. So there are options to do that and to discover the information that you need to know to properly manage your workplace. One quick question here. Let's see, we've only got about 4 minutes left. You mentioned this is based on Ontario law. Do these principles apply to other provinces in Ontario? Generally, the same principles apply with nuances in the application of those principles. So Ontario has a very robust human rights regime scheme where there's a duty to inquire, there's a duty to collaborate, there's a procedural duty, there's a substantive duty, and all of this is baked into both the code itself and the case law, and that's not the case in some other provinces. But following Ontario standards generally will allow you to be compliant in most other jurisdictions. Um, the federal jurisdiction is different in that it doesn't have the same requirements on employers. It has different requirements, but it's a different regime. So, if you do have questions about other provinces, please ask us, and there may be specific uh, application to those jurisdictions. See, we got a finished slide coming up here. So our next webinar is performance management, terminations, and severance, what employers often get wrong. And I'm well familiar with this presentation. It's a good one. I encourage you all to, if you have time to attend, to do so. Thank you very much for your time today. If you have any questions, follow up, please. Here's our email addresses. Just shoot them at us, and we can try to assist as best we can.